The person who will be leading this workshop is our Cook County Clerk, Monica Gordon, and I am going to provide some information about her. Very quick, because I know you may have a lot of questions for her. When she was sworn into office on December 2nd, 2024, Monica Gordon became the youngest woman and just the third African American to serve as the clerk of Cook County, one of the largest consolidated clerk's offices in the nation. As clerk, Mrs. Gordon has many wide-ranging responsibilities, including serving as the chief election authority for suburban Cook County, securing and administering vital records, and recording and maintaining land records and other official documents. Mrs. Gordon also plays a crucial role in the property tax system, maintaining delinquent tax records, tax maps, and information regarding TIF districts. She also functions as the clerk of the Cook County Board, preparing board agendas, post-meeting reports, and official county board records. The clerk also operates a veteran service division, providing the free recording of veterans DD 214 military discharge papers. Please join me to welcome Cook County Clerk Monica Gordon.
Hello everyone, how are you today?
Good.
I'm Cook County Clerk Monica Gordon. I am elated to be here with you guys. And so before I was clerk, I was Cook County Commissioner of the 5th District, which is the far south side and the south suburbs. And I could not imagine being clerk. Unfortunately, the reason I am clerk is because my predecessor, who was also my mentor, passed away, the late, great Karen Yarbrough. And me coming from a commissioner background where I was more of a legislator, playing more of an executive role was intimidating to me at first, because as you know, the Cook County Clerk's Office does a plethora of things and provide a plethora of services for the community. But I would say that it's been a wonderful experience. I have an amazing team, and just to have the ability to improve someone's quality of life and help someone with a milestone, one of their life's milestones, has been incredibly rewarding for me. But in particular, this forum, or this seminar, The Property After Death, is one of those seminars that I notice the community finds extremely beneficial and helpful. And a lot of times that's a hard time, right? That's one of those milestones we don't want to even think about. Death, especially the death of someone we care about and we love. But this is important information that we want to share with all of you. And if you have any questions, we have an astounding and comprehensive team that are dedicated to providing the services you need and give you the information that will help you during this difficult time. So, I want to be able to introduce you to my incredible team, the people that get everything going and maintain everything from day to day. But I know throughout the seminar and throughout the introductions, we will be introducing everyone. So I want to thank you for coming today and taking a step in the preparation for a milestone that we all face. So thank you so much for attending today. And please pass the word about this service that we offer, about this seminar that we offer, so other people who may need this type of service can, have their needs met as well. But I want to talk about someone specifically on my team who really organizes these types of events. And when I say organize, I mean she does the outreach, and she has a team to help her do the outreach. But she does the outreach to make sure we're covering all of Cook County. See, we don't want our services to just be in one part of Cook County. We want to embrace equity and make sure everyone in the county has access to these types of programs. So first and foremost, I want to introduce my special assistant to community affairs, the woman who puts a great deal of work and effort into each one of these seminars and getting all of you out and making sure they're all over the county. But I want to introduce again my special assistant to community affairs, Robin Staggers.
Good afternoon. I think I saw a lot of you upstairs at our resource table, right?
Yes.
Raise your hand. Okay. So a lot of you didn't come by our resource table, but you can get the same information you got at our resource table that's in the back of the room. I am Robin Staggers, and I'm the Community Affairs Liaison for Cook County Clerk Monica Gordon. Now, how many of you have a plan for your transition in life? In other words, I don't mean just transition going from one room to the other. I mean going from one earthly room to a heavenly room. How many? Okay. How many of you have a will? How many have a trust? How many have nothing at all? Okay, you're in the right place. We got some good information for you, and we're going to play a video for you to introduce you to how you can transfer your home, your car, your bank account without a will, no trust, no legal fees, no court costs. That sounds good, right?
Yep.
Yeah.
And it's practically free. It's not free, but it's practically free, but it's at a minimal cost. So we're going to play the video for you. Write your questions on the index cards you've been given. You were given a packet when you came in, right? So you should have index cards, how to check your deed card, forms, property fraud alert form, and the transfer on death instrument. Who doesn't have them? Can we give them a packet? Keep your hand up so that they don't know who you are. So we are so grateful for you being here. This is some information that we have found over the years of doing this program that is sorely needed throughout the community. A lot of people have passed away without having a plan in place, thinking that their properties were going to automatically go over to their family members. How many of you think that? No. We're going to teach you that you have an alternative. And that alternative lies in the Cook County Clerk's office, okay? So pay attention. If you have questions, write your questions on the index cards so that when we start the question and answer session, that your questions will not interrupt the flow of the program, okay? Who didn't get it? Okay, we're glad you're here. Let's go.
Please note, there are lawyers present today who work for the Cook County Clerk's office, but although they are lawyers, they are not your lawyers. They can answer any questions related to the office, but they cannot and will not offer you legal advice. However, the volunteer attorneys on this panel today are sharing their time and expertise with you as a public service. They are not paid by the clerk's office to be here, and you are free to consult them or any qualified attorney to address your legal concerns. There are free legal service organizations we partner with who are present here today. They can offer you legal advice for free. We would also encourage you to see if you qualify for their services. Thank you and enjoy the presentation.
Hello and welcome. I'm Monica Gordon, your Cook County Clerk. Thank you for joining us today for this important presentation on property fraud and managing your property after death. One of the main responsibilities of the Cook County Clerk's Office is to record and maintain property deeds and other property transaction records that take place in Cook County. In that role, one of the most important duties we have is to protect Cook County homeowners from property fraud. Unfortunately, there are fraudsters out there who attempt to file forged documents to illegally transfer the property of unsuspecting homeowners. Today, we will inform you about this issue and show you how you can register with our office for a free property fraud alert service to help protect your home and property. Another topic we will cover is making plans to manage your property after your death or the death of a loved one. We understand it can be difficult to talk about end-of-life planning, but it's essential to protect your assets to ensure the well-being of your family. At the Cook County Clerk's Office, we are here to serve. We hope the information shared in today's presentation will empower you with the knowledge you need to address these important issues that affect our daily lives. Thank you again for being here, and please enjoy the presentation.
Thank you, Madam Clerk. Before we begin our discussion, we want to let you know that we will have volunteer attorneys available at the end of the presentation who can answer your questions about the topics we will be covering. Now, let's begin our discussion by talking about making plans to manage your property and assets in the event of your death. As Clerk Gordon noted, no one wants to talk about death or end-of-life planning, but it is critical to manage your assets to protect your family and loved ones. Having a sound end-of-life plan is one of the greatest gifts that you can provide to your children and family members. Consider this. What do you think these three legendary individuals have in common? Prince, Aretha Franklin, and Abraham Lincoln.
87 years ago.
They have something very unfortunate in common. They failed to make plans for their assets upon their death. No will, no trust, no plan. Now let's consider someone who thought he had it right.
Wow, I feel good.
Music legend James Brown, the godfather of soul. When he passed away in 2006, Brown's estate was worth an estimated $90 million. When he died, Brown left behind a plan for most of his estate to pay for scholarships for children in need in South Carolina, the state where he was born. But that will was challenged by family members after his death, resulting in more than 12 lawsuits. It took more than a decade of litigation before Mr. Brown's assets were designated as he had intended. So, how do you get it right when it comes to your property after death? The best advice is to consult with an attorney or estate planning professional to provide you with advice for your specific circumstances. But you should also know that under Illinois law, you can transfer your home, your car, or your bank account to a loved one without a will or trust and without having to pay fees or court costs. Here are the details on how to transfer your property. First, the transfer on death instrument. The clerk's office offers a free document on our website known as a transfer on death instrument, but we call it a TODI. Beyond the clerk's office, you can also obtain this document at no cost from an attorney or a legal aid organization. The form should be completed and notarized and then recorded at the clerk's office in our recording operations division. The transfer on death instrument will then be recorded on your property's chain of title, and upon your death, the person designated to receive your property can do so after completing the required forms. While in the process of completing your TODI, be sure to contact the individual you plan to give the property to. Advise them they have up to 2 years to come to our office, complete the required forms to accept, and pay the recording fee. Please note that the clerk's office cannot assist you in the preparation of the transfer on death instrument or any legal document, and we do not provide legal advice to customers. Next, let's discuss a payable on death instrument. You can transfer the funds from your bank account in a similar way. Utilizing a tool known as a payable on death instrument, a person can transfer assets in a bank account to the beneficiary of their choosing after death. A payable on death instrument can be obtained and used at most financial institutions for checkings and savings accounts, certificates of deposits, money markets, and savings bonds. Even if you have completed a payable on death instrument, the account holder has full control of their funds in the account until their time of death. When the account holder passes, the beneficiary can claim specified assets directly from the financial institution without having to wait for probate court proceedings. Finally, let's discuss a beneficiary affidavit. There is also a mechanism to transfer your car to a designated beneficiary A vehicle owner may change, add, or remove a beneficiary on the title of their car by completing a free beneficiary affidavit through the Illinois Secretary of State's office. Keep in mind that if money is still owed on your home or vehicle at the time of your death, your beneficiary will still be responsible for the mortgage and payments moving forward. To obtain this beneficiary affidavit, go to the Illinois Secretary of State website at www.ilsos.gov. Now, let's move on to the second part of our program, property fraud, which can also be known as deed fraud. So what exactly is property fraud? Property fraud is the fraudulent and illegal recording of a document against your home's property records. We call it paper terrorism, and it is a very real problem and potential risk for all property owners. How can this happen? Almost every state has an open and public recording system, meaning that you cannot freeze your chain of title like you can your credit report. Plus, county recorders are not authorized by law to validate legal claims made in documents. Property fraud can involve the recording or filing of false or forged transfers of ownership, quitclaim deeds, or the filing of a bogus lien to steal property or harass an unsuspecting property owner. Even if your home is paid off, that does not stop someone from filing a new deed on top of it without the property owner's knowledge. Let's look at this investigative report that takes a close look at how property fraud can occur.
Now to scam you, and Rebecca, you have a story about a scheme that literally hits close to home for a lot of people.
Yeah, Whit, this is a warning about criminals stealing your most prized possession, your home, and you're about to see surveillance footage that authorities say shows the scam in action. This may look like a normal day at a county clerk's office, but look closely at this couple in the waiting room. Prosecutors say Michelle Cherry and her husband Victor Rodriguez were there to steal a home from unsuspecting owners.
To have someone steal your property it's like stealing the American dream. It's terrible. We've seen a big increase in that sort of activity.
According to Florida prosecutor Mike Lennon, Cherry made 3 trips to the clerk's office, stealing not 1, but 3 different Tampa area properties with fraudulent documents, using quitclaim deeds, a type of deed that can quickly transfer ownership of property.
They looked for properties that they believed were abandoned, and then they used online information to forge signatures on these deeds to file them with the clerk of court.
Prosecutors say one of those properties belonged to Larry and Dreama Bilby.
Just like that, your house is stolen. Yeah. It's gone.
It only cost 70 cents and some paperwork.
The Bilbys tell us they weren't living in their home at the time because of construction, but they were monitoring their home security cameras, which they say showed the suspects on their property multiple times.
They took our power bill and our water bill. They shut off our name and put their names on it.
The Bilbys credit their county clerk's office with alerting them of the change in the home's title.
Anytime anything is filed against your property, you get an alert, whether it's a phone call, a text, or an email. It is a free service.
Even while Tampa police were investigating, the suspect seen here in this body cam video adamant the Bilby's home belongs to her.
I own it. I'm on the current deed.
They were stealing these properties with the intent to try to get loans out on the properties or to try to sell them to unsuspecting buyers.
Both suspects arrested.
You have a warrant?
Yeah. And charged with conspiracy to commit fraud. Some officials are now calling for state laws to be changed, making it tougher to sell properties using quitclaim deed forms.
The fact that the form is so simple and requires so little documentation is problematic.
If you don't sign up for property fraud alert, you're just asking for the possibility that the same thing that happened to us.
To combat this problem, the clerk's office has a property fraud unit with investigators and caseworkers who respond to and investigate any complaints of property fraud. Our office also offers a free property fraud alert that will provide a telephone call or email to the property owner anytime a document is recorded against their property or the property of a loved one. There are 3 easy ways to sign up for the clerk's free property fraud alert. You may sign up in person at the clerk's office, sign up online, or sign up with a telephone call. Once registered, if you receive an alert or have reason to be concerned about property fraud, you can contact the clerk's property fraud unit, and our staff can help research the problem and coordinate a response. Call 312-603-4000 or visit our website at www.cookcountyclerk.com/property-fraud. On a related note, while we're on the topic of your chain of title and fraud, property owners often need to obtain an official copy of their property deed when purchasing a home, or for tax purposes. You should be aware there is a predatory practice aimed at homeowners in which companies offer a copy of your property's deed at a large markup price, sometimes exceeding $200. The clerk's office wants to remind you that we offer the same service at a more affordable price. So there's no reason to pay exorbitant prices to gain access to these essential documents. Check our website at www.cookcountyclerk.com/recording fees to get a full list of prices. On behalf of Clerk Monica Gordon, we hope that you have found this presentation useful. The clerk's office is your first line of defense against property fraud. So we hope that you will take this opportunity to sign up for our free property fraud alert if you have not already done so. Managing your property and your assets in the event of your death is also critical to protect your family and your assets, and to ensure that your wishes are carried out after your death. A copy of this presentation is available on the clerk's website if you would like to review it again or share with a friend or family member. Go to www.cookcountyclerk.com/PAD resources to view the presentation. For more information on how to host a property after death property fraud forum in your community, contact our special assistant to the clerk for Community Affairs, Robin Staggers, at 312-603-3974, or email robin.staggers@cookcountyil.gov. Now, let's ask the volunteer attorneys who are joining us to introduce themselves, and we will open up our presentation for your questions.
While they're introducing themselves, please, any questions that you have, please write them on the index cards, and we're going to collect the cards and present the cards and questions to our attorney.
Well, good afternoon. I said good morning first, but that was all. My name is Marlo. I'm an attorney with the Center for Disability and Elder Law. We're a nonprofit free legal service that provides estate planning, doing powers of attorney, transfer on death instrument, last will and testament for free. We do that for seniors, people who are 60 or older, or if you have a disability, regardless of your age, if you live in Cook County and make a low to moderate income. So we're one of the free legal aid services. And if you want more information about getting in touch with our program, we've got a table at the resource fair as well, but I also have pamphlets and cards we can hand out to you.
Hi, yeah. Hi, so I'm Eva Adams. I'm an attorney with the Center for Disability and Elder Law. You just heard about us. I do just want to plug real quick that I have a legal help desk that's in the clerk's office. It meets at bi-weekly on Wednesdays from 10 to 2. It is by appointment only. You can sign up for that for an appointment via the clerk's website. I believe it's the same website that's online. With that said, we pre-screen everybody who comes through. We want to hear your legal issues. Some people only get advice because some things we can handle with you having the resources you need, and you don't need to come in person. I'm going to pass that on.
Good afternoon, everyone. My name is Jim Gillespie. I'm the Chief Legal Counsel for the Cook County Clerk's Office. Welcome you here today.
Hi, welcome. My name is Ken Trin. I'm from the Cook County Clerk's Office as well, and I'm a supervisor of the fraud unit and legal counsel for recording operations.
You introduced yourself already? I'm slow. Sorry. You did? Okay, so they're still collecting the questions. So what I want to do is introduce our staff that's with us today. We have Carlos Rodriguez, who does our AV and all of that. He makes this possible and putting together flyers and all that kind of stuff. He's my partner in crime. I have Madison Bowen, who is the outreach specialist, and Brittany Preston, who is an outreach specialist. This is their first event with us, Brittany and Madison. We're elated to be here. I'm happy to be partners with, or we're happy to be partners with the Center for Disability and Elder Law. But I want you guys to know that we don't only do property after death. We have a Veteran Services Office. So if anybody in here is a veteran, are you a veteran? No? No veterans? We have a Veteran Services Office. We have a Vital Records Office where you get your birth, marriage, death certificates from our office. So are you familiar with that office? Yep. You should be. Yep. Everybody has a birth certificate, right? Yep. Okay. And we have tax services. So if you've lost your property for the taxes, we have an office where you can come and redeem the property and pay those taxes back. So we do a lot of things in the Cook County Clerk's office, and we hope that the information we bring today will be of help to you. So, did it help?
Yes.
Yes, good, okay. So I'm gonna start on the questions for the attorneys. If property and assets can be transferred so easily with a toady, what do wills and trusts offer? Second part, why should we do them? And is there more protection in case of dispute?
I can take that one. So essentially a toady is part of a toady, any pay on death account. Those are gonna be part of a comprehensive estate plan. So right now that toady is gonna happen at death. That's gonna remove your house from your probate estate. But we're looking at a power of attorney for healthcare, power of attorney for property, a living will if you prioritize the quality of your life over the quantity of your life. And then your last will and testament is for when you pass away. Depending on whether you go to probate or not, that last will and testament will tell the judge how to divide your assets, or if there is no will, the state has a proscribed version of that. The reason you would want a toady is that if you don't have significant assets, the toady may be the thing that keeps you under that $100,000 threshold for assets or owning real property. That may keep you out of probate court. Compared to a trust, trusts are phenomenal documents. I don't know the legal aid organization who is drafting them right now. With that said, that's not to say they are bad. There are very great reasons to use them. The difference between a trust and a toady for property specifically is privacy. That trust is going to be a private document, whereas the toady is recorded against your property index number. And then when it comes to protection, this was a comprehensive question. Trusts do offer a level of protection, but trusts are complicated documents. The more you give up, the more ownership of your property you give up in the trust, the more protection you get. It's not automatic. And I think that was all of those elements. Did anyone want to add anything?
I have one little thing to add. So just one little thing to add is you did say probate court a lot. Probate court is the process when someone dies that if there is no plan in place, so there isn't a will, there isn't a toady, there isn't a trust, usually if there's any property to be divided up that has a title to it, like a deed, then you're gonna have to go to probate court to get that new deed issued. So what Eva was talking about with probate court is there's this $100,000 cap. If whatever you're putting into the court is worth less than $100,000, you usually don't have to go through this whole court hearing process. So what most people are trying to do with their estate is get beneficiaries named so that anything that's left over that doesn't have a beneficiary named is less than $100,000. That means if we have an estate of less than $100,000 with beneficiaries named on everything like the home, the car, your bank accounts, then we don't have to go through the court process at all, the probate court process, because that will cost you money. I don't believe most probate judges will do a pro se probate case, meaning they're going to ask that you have an attorney representing you through that. So the only legal aid I know of right now that represents people in probate estates is Chicago Volunteer Legal Services, and they only do really simple, small estates. So for most people, getting that plan in place ahead of time so that everything that's worth some money has a beneficiary named that just automatically transfers on that person's death to the beneficiary, that's the goal we want to go for, so that we don't have to go through probate court and pay the big price tag and hire an attorney, and the months of, that process means that you're waiting a lot of time to get that benefit when somebody dies.
And just adding as a matter of information, probate court applies whether you have a will or not. It's just, the will is actually the document that would allow you to say how you want your assets to be divided when you pass. If you don't have a will, there's a plan. It's called the intestate laws in the state of Illinois. So the government has made a plan for you if you decided you didn't want to make a plan. Probate takes, time and money. I can tell from personal experience. I had a family member pass away in 2018 in January, and it was a little bit more complicated because he had property in several states, but at the end of the day, his estate didn't get wrapped up until I think 2022. So a lot of folks don't want to wait 4 years for something like that to be resolved. And so a transfer on death instrument is a tool that we can use in our tool belt to make sure that we can transfer our assets in a way where you don't have to expend the inordinate amount of time and money to wrap up, the estate of a loved one.
What happens with the toady if you have debt?
So it depends on the type of debt, usually is the lawyer answer, but if you have debt, the transfer on death instrument, if you have like credit card debt, unless it has something to do with the house, that they got a lien on the house with that debt, the transfer on death instrument will actually remove your home from your estate, meaning that if creditors come calling after you passed away, they can't touch the house usually if you put it in a transfer on death instrument. Now there are exceptions to that, as there are many exceptions in the law, but the general rule of thumb is when I do a transfer on death instrument, I'm removing that home from my estate, so creditors can't usually come after it if they're trying to get something from my estate, because it's no longer in my estate, right? The other thing is for a mortgage, that will run with the house. So when somebody passes away, if there's a mortgage on the house that's not all the way paid off, whoever they transfer the property to in the transfer on death instrument will now have the standing to go to the bank and say, I'm the new title holder, do business with me. I'll start, paying off a mortgage, but we just got to refinance it out of my deceased family member's name now into the title holder's name, which is me, because I'm on the transfer on death instrument. I've seen that happen in lifetime, and it makes it so much easier for family members who are moving into the property to have that security, that they're on the title. Now the bank will actually work with them, and they can assume the mortgage too, even though the mortgage does still have to get paid off.
Those are great points, especially the latter point about the mortgage. I've been to a lot of these seminars where someone says, hey, my parent passed away, I have the property now, but the bank won't talk to me. And they said they're going to foreclose on the mortgage, and I don't know what to do. That happens all the time. I think the banks don't necessarily have to deal with you unless you are the record owner. So it does make it a lot easier to deal with the transfers. And also, just as a side note, don't wait too long after the passing of a relative to try and deal with that, because it's just going to make it harder.
You mentioned a threshold, a $100,000 threshold. Is that only in the state of Illinois?
I can take that. So every state has different probate laws. So I can't speak to the laws in any state but Illinois. Here in Illinois, to go through probate, you either have the person who's passed away either has over $100,000 worth of assets, they have real property like a home, And those are the two that are most general. Those are the ones that we like talk about the most. But somebody can have unknown deaths, or the family could have some infighting. They could be contesting that toady. They could be contesting the will, and only a court would be able to do that in probate.
Yeah, and the $100,000 limit is in Illinois. If when you pass away, your estate contains $100,000 or less, you can instead of opening up a whole probate court case and going through the court process, getting a judge to issue you new deeds, all that stuff, you can file, or the executor or administrator of the estate can file what's called a small estate affidavit that just says to the clerk, here's the death certificate, here's the information about the person who has passed away, here's a copy of their original will if they have one. If they don't have one, we just check the box that they didn't have a will, and then we list what their assets were. And if their assets come out to less than $100,000, just filing that small estate affidavit at the court will mean we don't have to go through the whole probate court process. Now, if there are any creditors who come calling, that's the packet I say, if a creditor calls you and says your family member died, they left this $10,000 debt, who's gonna pay for it? Well, they passed, here's their small estate affidavit saying they didn't have, much of anything, less than $100,000, and certainly not any liquid money that I could give to you, creditor. That usually makes the creditors go away too. So a small estate affidavit is another really useful tool that if you're under that $100,000 cap in your estate, you can just fill that out, file that with the court, and then we don't have to go through the whole big court process.
Okay, can I add more than one person to the transfer of my house?
Yes. Yes. Easy question. Also, it's just going to depend how you give it to more than one person. There are two basic types of joint, or rather not joint, I shouldn't say, but when two or more people own a property together, there's two different general ways that works. Either as joint tenants, meaning that they have a right of survivorship over the other. If with joint tenants, they're going to have to work together. Nobody can just sell the property out from the other, under the other, because they've got a right of survivorship, meaning when one of the people in the group dies, their share goes to the other joint tenants, right? So that's joint tenancy. The other kind is tenants in common, where you can just split it up in terms of percentages. There's no right of survivorship, so people could take, any of the people on title who are tenants in common could take their 20% and go sell it without telling the other people, do what they will with it. So there are benefits and drawbacks to both kinds. It's going to depend on your situation, what is best for you. But nonetheless, you can put more than one person to receive your property on a transfer on death instrument. When you start getting into the 5, 6, 7, that's usually when I say, whoa, I don't think that many people are going to be able to work together. But you just, you have the option to do it. Usually I just advise, try to keep it to a reasonably sized group of people who are going to be able to talk to each other and work together.
I just want to add to that, when you're drafting these documents, one, they're completely revocable. So if you draft a toady, you change your mind later, you can record a new toady. It's still $59, you'll just pay that $59 again. When we talk about beneficiaries, we do like to create these documents to have some type of longevity. I'm an attorney, I like to plan for eventualities that may never happen. So if you list a successor or a beneficiary, if you list somebody like your oldest child and they predecease you, we have listed successor beneficiaries. So whenever you're drafting this toady, you want to think, what if someone predeceases me? What if my children don't outlive me? We don't want to think about it, but we do think about it. That way we can have a plan B written into that document.
Okay. Can a payable on death instrument be challenged, and can you clarify it?
Anything can always be challenged in court, usually. If people think there's some kind of undue influence or fraud, that's something that they would have to file a claim in the court that the payable on death instrument was invalid for fraudulent reasons or whatever the reasons were. Sometimes that's not fast enough to catch it. but it would be if you were able to prove in court, that this person defrauded my grandma, kind of forged their signature on this payable on death instrument with the bank, then you would have a court order saying, that person owes you that amount of money. The thing with a payable on death instrument that's so nice but can also be a danger is if when somebody passes away, usually if there's a payable on death instrument on the account, all that the person who's named as the beneficiary on the payable on death instrument needs to do is take the death certificate to the bank. The bank releases the funds or renames the account in that beneficiary's name. So usually that's why we say don't wait, get on top of these things now so that it's clear. And every financial institution has their own process for how they're going to add a payable on death instrument. The financial institutions like the banks really don't want PODs that are fraudulent. So they do their whole process to make sure that it's the real owner of the account, owner of the bank account who's doing this. And they make you fill out their own forms and notarize them as each bank requires according to their internal systems. So it should be very difficult to do a fraudulent payable on death instrument, but being a possibility, I always say just double check with your banks, double check with anything that you've recorded, any documents you have. Usually every 5 to 10 years is a good time period to recheck your estate planning documents, just to make sure everything's looking good. We don't need to update it or change anything.
And another thing to add about the payable on death instrument, and sometimes people think an alternative to doing the payable on death instrument would be to just add someone to your bank account. Says, I don't want to deal with payable on death. I'm just going to add this person to my bank account just in case something happens to me that person would have access. I don't think that's a very good idea. And I have a life experience that can explain why. Sometimes it's not even the intention of the person who you're putting on the bank account to do any harm. But for example, I was in college and I received a substantial student loan, to pay for my school. The money went into my bank account. My bank account was a joint bank account with one of my parents. One of my parents, unbeknownst to me, was going through some significant financial troubles, and unbeknownst to me, was having problems with their bank. So upon my putting the money in my bank account, the bank took it. And they had every right to do it because my mom owed that person, they owed that bank money. And there's nothing I can do about it. So be mindful of when you're thinking about putting someone's name on your bank account or putting it even on your property, what that actually means. It could have tremendous consequences. So it's just a contrast to a payable on death instrument where you do the payable on death instrument with beneficiaries. That beneficiary has no right to the funds while you're still alive. That beneficiary has financial troubles that does not affect you in terms of your bank account. So just noting the difference between the two practices.
And that's going to be really similar for the toady as well. So that toady for your house is only going to be effective the moment you pass away. So whoever is your beneficiary won't have access to your home until that moment. So I like to contrast that with the quit claim deed. We heard about that. We saw how easy it was to do that, and it's a tool that some people use to try to circumvent this document or have used it in the past to try to pass on their property. That adds somebody to title with you. So if they have any judgments against them, they have bad credit, that could result in a lien on your home. You are now sharing that with your co-owner. So that's why this toady can be really beneficial.
Is a transfer on death legal for a home with a reverse mortgage?
Yes. A mortgage has no bearing on whether you can do a transfer on death instrument or not. You can have any kind of mortgage on the house. However, that is a reverse mortgage usually comes due upon the death of the person who held that reverse mortgage. So that's something to keep in mind. Often with reverse mortgages, if they weren't done properly, or if you got the idea of a reverse mortgage is you're borrowing against the equity of your house, with the understanding that when that person passes away who owned that house, then now you've got to pay that loan back. And so for most people, they end up having to sell the home in order to pay back the reverse mortgage. So that's just something to keep in mind. But a regular mortgage, you can usually just, as the new title owner under a transfer on death instrument, start paying off the mortgage with the bank. You got to talk to the bank, get the mortgage put into your name, but then you can usually just start paying it off. The reverse mortgage is a little trickier because it comes due upon death.
And this is a really good moment to include, you can't make somebody take a gift. So if your home has money owing against it, if there is a reverse mortgage, this person doesn't have to accept the toady. When you pass away, they could disclaim that property. That's a complete option. So don't worry about leaving something to a beneficiary for fear that they may not want it. They have choices.
What is a quitclaim deed, and can I use a quitclaim deed to transfer my home upon my death?
Usually no. You're usually not going to be able to use a quitclaim deed upon your death because a quitclaim deed needs to be signed by the property owner. If you're dead, I imagine you can't sign a document, right? So a quitclaim deed, what most people will try to do is, we talked about it a little bit under the last question, people will try to add an owner to their house while they're still alive using a quitclaim deed, saying, you know, I need this home for myself, to myself and my child as joint tenants, so that when I die, they just are the other joint tenant, they automatically own the property 100%, right? We wouldn't usually recommend that for the same reason we just talked about. If you are adding someone using a quitclaim deed while you're still alive, their creditors can start looking at your house as if it's that person's asset, because it is. Once you add them on a quitclaim deed, that property becomes theirs just like it's yours. You're both owners. And so we see, unfortunately, seniors who will add a child on their quitclaim deed, but then the child has financial problems. They get a lien on grandma's house now because grandma just wanted to get some estate planning done. So we normally say that's why the transfer on death instrument is a better option, because it doesn't change anything about your ownership of the property until you pass away. And if you still own that property at the time you pass away, that's when the transfer on death instrument kicks in and gives it to that beneficiary.
And I just want to remind you, like, if you've already used this as a tool, it does work. It can work. Up here we see some of the worst situations happen every day, and that's ignoring the fact that sometimes everything goes according to plan. We don't plan for that, but sometimes it does happen. So if you've already used that as a tool, you can't undo it because you would need the permission of both owners. But it can work. So don't feel like we've told you that, like, oh my gosh, this isn't gonna be like satisfactory. It can work. It's just not what we recommend.
What if your property was not recorded in the Recorder of Deeds office? What should you do? All properties.
Is it, for clarification, do you mean if your deed wasn't recorded with the Recorder of Deeds office?
Yeah.
Okay, that sounds like that's what, so someone received a deed for a property and they didn't record it.
We would need a little bit more information on this one. Technically speaking, a deed doesn't have to be recorded to be valid. But if it's not in the chain of title and it's not recorded and something subsequently recorded, it could affect your ownership. So like, you would really need to seek counsel and specialized advice on that one.
And if you have a deed out there that gives you an interest in a property, please record it.
What if you want to name an organization instead of a person on your toady? Do they pay the same fee? And what is the fee?
Well, so the recording fee for the toady to record the transfer and death instrument, the initial document, is $59 flat, regardless of page count. And for any acceptance affidavit, that would be $107 or $112 if they mail it in. So that's a flat fee.
Can you name a person, an organization instead of a person on the toady? Can you put an organization instead of a person on the total?
Sure, does that organization know that you're gonna give them the property? Right, so if you're in that type of situation where I think that's some kind of endowment type of situation that you wanna plan on, you should be talking to first your own lawyer on how to do that and how to do that effectively, and then in communication with the people that you're going to give that property to. I think that's really important. If you're going to make a plan, you got to share that plan. Don't hide the plan. Time and again, unfortunately, because I'm in the fraud unit, we get questions about where can I find a trust document that my grandparents executed, and we clearly see that the property's owned by a trust, but we don't have the trust document. And grandma and grandpa just put everything in a trust, but then, where are the documents? So if you're gonna make a plan, use a professional, and then share that plan. Make sure that your beneficiaries know that you've made a plan.
Okay, explain what happens with squatters, first part. Second part, does the toady help with squatters? And what can we do to protect our property from squatters who create fraudulent papers?
So I think that's I'll bifurcate that question. So squatting is somebody just running into a property and just sitting there, right? They're just gonna occupy your property. That's different from the type of fraud that was in the video, where a person comes in and records a document claiming that they own that property. That's deed fraud. So there's two different issues going on here. So in the news that you've heard about the people that will go and pop the lock on properties that's for sale and then just say, hey, this is my house now, and it's almost impossible to evict them, right? That's a different situation altogether, right? And I want to describe the situation where somebody goes in and records a deed against the property that's bogus. Say they sign your name to it, to themselves, right? So that's deed fraud. So those are two different type of situations. They can merge, where it's a property takeover, where they both record a deed and then they get into your property. Those are two different situations. A toady is not going to help you protect from that. What helps protect from that is signing up for a property fraud alert. It's totally free. You can do it today. We've got the handout, or you can do it at home online. And what that does, that property fraud alert, it's free. Again, free. It alerts you to any document that's recorded against your chain of title. So if you record a document or you refinance and your bank records a refinance document against your chain of title, you get an alert. If there's some fraudster out there recording a document against your property, you'll get an alert. So I hope that helps you understand what can help protect. And you can help protect yourself by signing up for that free property fraud alert.
Okay, can I follow up that question by saying, what should a homeowner do if they become victims of squatters?
Well, so again, it's a two-part problem. Our fraud unit can help you if that squatter recorded a bogus document. What we're not able to help you with is the eviction process. That's a process that you actually have to go to court. Hopefully you'll be able to find a lawyer to try to evict that person from your property. So that's why it's a two-part problem. Which problem are you having? And I'll add that the type of fraud that we're dealing with now, we've got essentially two types of fraud. One is property that's vacant and abandoned. It looks vacant or boarded up. If you've got a property like that, be aware. Somebody's looking at that property and they're observing it, and they're observing to see whether there's anybody in interest there. And if there's not, they'll try to record a bogus deed. The other type of fraud will relate to property that isn't quite abandoned, looks good, but it's empty. Could be a property that's for sale. And this is a new type of fraud that's out there, and it's called seller impersonation fraud. That's a fancy word for identity theft. And again, if you got property out there, sign that up for a property fraud alert. You can sign up for as many properties as you want. You can sign up separately. You can also add your trusted family members to receive that alert. Just make sure that your trusted family member knows that you signed them up, so that way they don't get a heart attack when they get an alert from us. Hope that helps.
Okay, with a toady, will the new owner be required to pay capital gains? For example, my mom paid $30,000 40 years ago. Now it's worth $300,000.
No. So I can take this one. I recently looked it up because I had it as a question. So when you inherit property, you get a step up in basis. I know that none of y'all talk tax. So when you bought the property, that $30,000 was the basis. That is the basis that's used to calculate the tax. If there was a capital gain, it would be calculated on that $30,000. So what is it worth today versus that $30,000, subtract the number, that's, what the number would be used to calculate that tax. When someone passes away and you inherit property, you get that step up in basis to the fair market value of the date of death. So there is no capital gains tax on that.
It would, if you sell the property immediately after you receive it, it might be a different story. But just receiving the property, I don't believe has any kind of capital gains tax on it.
Does a toady apply to shares in a co-op?
It depends on how the co-op is established. Is it established with separate units and separate PIN numbers that are recorded with the Cook County recorder? You usually have to have a single PIN number in order to, each toady has a PIN number and a legal description associated with it. So if the co-op has multiple units that are kind of like individual condo units, yes, if each individual unit has its own property index number, its own PIN number, its own legal description, you could leave that unit to and that happens with condos too all the time, where people will own a condo that's in a building. They don't own the whole building, but they can do a transfer on death instrument for the condo itself. However, if the co-op is like just a building that we've all agreed to make a co-op, but that doesn't translate to there are different property index numbers associated with each unit, then the owner of the property would own the property at whole, and you'd have to do the transfer on death instrument at whole for the whole property, as opposed to different co-op units. But Eva might know a little bit more about getting the property index number changed.
To be continued. I'm still working on that one. With that said, some of these questions that are getting a little more in the weeds, the answer will often be it depends, and you will want to seek individualized legal counsel to answer that question.
Okay, who would be responsible for any debt if a payable on death instrument, and what kind of debt would apply? Any answer?
Okay, I think I understand the question as being, if you're a beneficiary and you're on a payable on death instrument, so grandma has a bank account that's got $10,000 in it, she named you the payable on death beneficiary of that $10,000 bank account. What that does is just making the payable on death instrument removes the account from grandma's estate. So if the question is, if grandma has creditors and they want to get at that $10,000, usually they're going to have to file something in court in order to come against the estate to get that money. So with the payable on death instrument, once again, it's going to depend on the fact situation as to whether that creditor can get at that money. But usually, generally, when we do a payable on death instrument, it removes that account from my estate. So then, therefore, it's not in the pot that creditors can try to get at. And this is also an important piece. When we pass away, our debts don't automatically go over to our family members, right? This is something that a lot of credit card companies, unfortunately, will try to make misinformation into now they've got somebody else on the hook to pay off grandma's debts, right? So when a family member dies, sometimes they'll get calls from these creditors. Family members will be told, you know, your grandma left so much debt behind. How are we going to deal with it? If they can get somebody on the phone to say, yeah, I can pay off, I can make some payments on grandma's debt, now they have an enforceable debt against that person who's still alive, which is usually what they want. They want to try to do collection activity against somebody who is living so that they don't have to start out the gate paying hundreds of dollars to just file a case against that person's estate. So I say that to say, make sure that you know and your family members know, if I have debt, here's the debt that exists, and you know, you should not agree to take over any of my debt because you don't have to. This is where, unfortunately, I've heard horror stories of people getting given the runaround and told they had to pay a debt that was their parents' debt when they really didn't have to. So just make it clear to your beneficiaries and your family members if you have debt in a good estate plan so they know and can anticipate how to deal with it.
Okay, are grave sites considered real or personal property? And does a will preclude going to probate court?
Oh, great.
So to try to, it's not going to answer your question directly about grave sites. We get questions about deeds for the plot, the grave plot, fairly often, and that is not a document that's recorded at the recorder's office. It's a document that is held by the cemetery, and that's why it's so very important when you're making all these plans that you let your somebody trusted, your beneficiary in particular, know what your plan is, because it's really tragic when I have to field a call or an email from a survivor and they're trying to find a plot for their parents when their parents told them that they have a plot but they didn't tell them what cemetery. So it's really important to know that, number one, they're not recorded at the recorder deeds office, and then two, if you do have a plot, to let your loved ones know that you do have it and where and the paperwork that's there.
When we draft last will and testaments, one of the questions is how do you prefer to be buried? Whether it's burial, cremation, or anything else you can think of. I've written a lot of things in there. With that said, when somebody says they want to be buried, I always ask, where? Have you prepaid for a plot? And what cemetery is it at? It's really important to include that information because if your family doesn't know, that there is no record of it unless maybe they come across a receipt in your house, which is, I mean, in this digital age, may be unlikely.
Okay. Question. What's most beneficial, a trust, a will, or transfer on death instruments?
It depends. The lawyer answer everybody hates. It depends. What the difference is, I mean, I would say at minimum, if you own a piece of property, if you own a piece of real property, a building, have either a trust or a transfer on death instrument. Transfer on death instrument is usually the most cost effective for people who own just 1-2 properties. If you own more than that, you're probably going to want to look at a trust because trust can get a lot more detailed in how the property is going to be managed after the death. You know, the trustee is going to be on the hook to make sure that the mortgage is getting paid off until we get a new deed issued, all of that. So if you have more things, usually a trust is going to be a little bit better. I would say for both those people, they would want to have both a toady and a will or a trust and a will. Or if you own multiple properties, you could do a toady for one and a trust for the other ones, right? So it's really going to depend on your situation. But nonetheless, I think a will is always better than having no will. Transfer on death instrument is always better than having nothing. And a trust is better than having nothing too. So the difference
being, if we don't put anything in place, that's going to result us in going by the Illinois intestacy statute, which is that one-size-fits-all plan for who counts as your closest kin who will get your stuff. And we all know that that doesn't always translate to who we would actually want to get it. So in a will, you're not necessitating, going through probate court or not. You're gonna have to go through probate court regardless if you have an estate that's large enough and you haven't named your beneficiaries. But with any of these options, having a will is better than not, because it'll say, here's how I wanted my property to be designated, so you actually get a say in it. I just want to back out of this 1 second. We've gotten really granular, and just to give you like the big picture one more time, these are all documents that are a part of a comprehensive estate plan. An estate plan is not one document. It starts while you're alive. You have the power of attorney for healthcare, the power of attorney for property. At death, you have a toady. You have the payable on death accounts. You maybe have a trust. Those documents activate at death. After death, you have the last will and testament. Ideally, if you're trying to avoid probate, you're going to have all of your assets taken out of your probate estate so that it'll be, again, small enough to do that small estate affidavit. Your last will and testament may deal with, your tea towels, your cups, your bedding, the things that maybe aren't high value but maybe have sentimental value. All of these documents work together. And of course, depending on the kind of asset, maybe a trust is more beneficial to you. Of course, we at the Center for Disability and Elder Law focus on low to low moderate income. So often we aren't referring people to do trust documents. That's not to say they aren't beneficial in some contexts, just that the people we help don't necessarily reap a lot of benefit for the cost of them.
So with a will, it's no good if nobody knows it exists, right?
You want to have your executor at minimum, the person you named in your will, as the person who knows where the original will is and can lay hands on it and take it down to the courthouse once you've passed away. Because in Illinois, we don't have a will recording receptacle where you go record the will before you pass away. You just have that original document that functions like a private contract until the moment that that person dies, and then the will goes down to the courthouse. So you need to have your executor. That's the person you put in charge of your estate. You put in charge of making sure my niece gets my grandma's pearl earrings or whatever you put in that will. That executor is tasked with taking your original will down to the courthouse upon your death to get it filed with the court. And best practice is to only really have one copy out there so that your executor knows where the original is, and only having one copy in existence. We've already talked about Aretha Franklin in the video, but of course she had multiple copies of her documents. The one that I think that was contested, the reason we know about this is there was one shoved in the couch cushions. It was not in a safe place, and her executor didn't know which one was the most recent, the one that was valid. So again, just knowing, at least having your executor know that where it exists is really important.
So if I have a will or trust and I want to put my property into a total, which one trumps? Which one is the valid document?
If you put the home into a trust, the trust is gonna now be the owner of the house as a legal matter. So when we do a trust deed, it's usually deeding the home out of my name into the trust itself. So once we've done that, if you wanted to do a transfer on death instrument, you have to deed the home out of the trust back into your name before you can do the transfer on death instrument. We've advised some people who did a trust before transfer on death instruments were even a thing. Transfer on death instruments were written into law in 2012. So before that, it wasn't even an option. The only option before 2012 to give your home to
to the next generation without having to go to the probate court and get a new deed, the only option was to do a land trust. So we've seen some land trusts that were entered into back before 2012 that now you're still paying an annual trust fee every year to keep the trust going, and it starts to look less like it's worth it. You want to remove the home from the trust, pay the fees to do that, get the new deed done, and then doing the transfer on death instrument will be more cost effective for you. That's, like I said, gonna depend on your specific situation. But usually it's either a transfer on death instrument or a trust. And I believe if you had a trust deed that said the home is owned by a trust, and then you tried to file a transfer on death instrument on top of that, the trust document would be the one that trumps. But it's gonna depend.
And then when it comes to I think the last will and testament was in there too. When you have a will and a toady, we do this all the time. We're going to draft that toady, we're going to give it to you, and you need to record it. It's not valid unless it's recorded. But while we're drafting that last will and testament, we're putting a clause in there that if in case it wasn't recorded, that will is going to give that property generally to the same beneficiaries. And you know what? If that house has been, if a toady has been properly recorded, that clause isn't going to invalidate the rest of the will. The property's not there, so it's just not going to go to that person from the will. It's going to go by the toady, so the toady would trump.
If a person fills out a transfer on death instrument and they die before it's recorded in the Cook County Clerk's office, then what happens?
The toady is null and void. It doesn't do anything. So even if you had it fully filled out, notarized, ready to go, if you didn't take it down to Robbins, folks, and get the stamp on it, it's like a piece of paper. It's worth nothing. So the transfer on death instrument, paying that $59 recording fee is really important, because then it's against your chain of title, which is what's needed in order for it to be valid upon death.
You know, indulge me for 1 second. Team, if a toady is in the mail and I pass away, nope, null and void?
So, well, we'll allow a recording. How about that? We'll record whatever you want to record, right? As long as it meets basic recording requirements, but is it valid? So that's the big thing. If it's important to you, and this is how I communicate with customers as well, if it's important to you, it's really important to you, come downtown. You know, spend a few hours downtown, come downtown, and record your document, same day recording.
What if she's in the hospital?
You can send someone.
Okay.
So the person that is the owner doesn't have to be the person that records the document. So you can send your family member, you can send somebody trusted, you can send it via FedEx, so we accept that too. But just to get off the course with toadies here, if you're preparing your own toady, it's like doing your own plumbing, right? Will it work? Will it leak? Is it correct? I have seen toadies where the legal description, which is, I hope everybody understands what their legal description is. So it literally legally describes your lot, and it's very technical language. Some people put in that, you know, they describe their house just like in a Redfin advertisement, and you know, do you think that's effective? That's a problem, right? So if you're not familiar with doing it yourself, definitely seek out that professional help.
And again, legal help desk.
If a beneficiary on a trust dies before the trust, they die before the trust, what should you do if you want to go to a toady?
A well-drafted trust, if the property's already in a trust, a well-drafted trust is going to have succession language in it. Again, if you want to do a toady and you have a trust, the property has to come out of that trust for the toady to be effective. And I can't speak any more specifically on that, just because there's so many different types of trusts, so you may or may not even be able to pull it out. That would be a fact question.
Yeah, you'd have to go to the, like Chicago Title and Trust is probably the biggest maintainer of trust that I know of in the area. You got to go to whatever that financial institution is that set up the trust. If it was a lawyer's office, whoever is the trustee on that trust document is supposed to keep that trust and all the terms in it, because it's going to depend. The trust works like a private contract. It's going to depend what's actually in the trust document as to how that happens. If somebody passed away who was a beneficiary in the trust should speak to it. But we got to go to that specific trust document, and that's usually a private document held by either the attorney who set it up for you or some company like Chicago Title and Trust that maintains trusts.
Okay, here's another question. So if you set up your trust with an attorney's office and the attorney dies before you do, how do I get my trust? How do I find out the nature of my trust?
Exactly. So this obviously comes up a lot, and there are rules for when attorneys pass away as to where those client files go. I can't speak to it specifically because I have not encountered it, but there is a succession plan when an attorney dies and is still in practice.
And attorneys are required to maintain records for, I believe, 7 years is the timeline. And so, yeah, that doesn't mean that attorneys are perfect and they're gonna maintain the records, right? So once again, being on top of these things, checking, double checking, that would be specific to the trust. Whoever is named as the trustee is usually gonna be the one who has that knowledge, has that trust document itself. You gotta find out who that person is, who that entity company is, and be going to them to ensure, yep, what's the plan for if this company goes under. A lot of smaller banks that maintained land trusts got absorbed into Chicago Title and Trust, right? And so now Chicago Title and Trust is the one that you would go to, but it's going to depend specific to that trust. Each trust is different. It's like a fingerprint. You got to go find the actual fingerprint and read it to see what happens next.
Yes, ma'am.
Okay, I just have a quick question. What if somebody inherits a home, they're the beneficiary, but it was a second mortgage taken out on that property, but you know how mortgage companies, they sell mortgages. So maybe the home mortgage is with one company, the equity line of credit is with another company, but that person has passed on. So how, what would happen? Because I remember you were saying, this is it, this person's debt, it was this person's debt.
Yeah.
Will they be responsible to pay that equity line of credit off, or how would that go?
So two different types of debt here you're talking about. There's the type of debt that is attached or has attached to the property itself, like mortgages, those are like a lien on the property. Then there's the type of debt that's just personal. That's like, I took out a credit card in my name and charged up $10,000 and I never paid it back. The kind that is just in my name, that one doesn't automatically transfer to your heirs at all. The kind that runs with the property, it's attached to the property itself, like a mortgage. So an equity line of credit, a second mortgage, those are all, they go with the property. So whoever gets the property afterwards, now they're gonna have to deal with all the liens on the property. And so that's gonna be for that beneficiary to decide, if they wanna get into it, they're gonna need to, take a look before they file their notice of death and acceptance of transfer on death instrument. They're going to want to do that with their eyes open to see, are there multiple liens on this property that I'm going to have to deal with? Is that worth my time and energy? If it's not, I can just disclaim and not take that property, not have to deal with that issue. So it's, once again, depending on the type of debt. One runs with the house, like a mortgage, like a reverse mortgage, or a second mortgage. One is just my individual debt. The kind that runs with the house is going to stay with the house, whoever picks it up.
Okay, that was the last question. However, this is pertinent to you having or your organization having one of these workshops. Are any of these workshops available in Spanish or Polish? Years ago, our workshops were held in Spanish and Polish, and we're working to bring those workshops back. We're getting requests from multilingual communities. So we're trying to set up events in those multilingual communities. Now you can get information on our website in any language, is that correct? There's a tab on our website that translates our information into whatever language you speak.
Yeah, I believe that's true.
Yes, so that has just been added. Yes, it's just been added recently. Will any of these workshops be offered on the Northwest side? We're coming. We need you to put in, or an organization from the North side to host one of these events. What we do is we encourage an organization to partner with their elected officials in those areas so that you can partner and bring as many people in those communities to these forums. We'd love to come far north, but we have not gotten an invitation yet, but we're working on it. We go all over the county, from the north to the south, from the east to the west, so we cover a lot of ground, and we like to partner with organizations that partner with each other. The requirement is that you have to have at least 50 people registered for these events for us to come out. We create the flyer, we create the registration page, we bring all the materials, we bring our whole kit and caboodle. I run Carlos across the county with me. We go to site visits to make sure that everything is set up properly, and then we bring the presentation to you. We partner with great partners from our free legal services, organizations like the Center for Disability and Elder Law, the Center for Volunteer Legal Services, and Legal Aid. We also partner with private attorneys who they don't have to. They're encouraged to volunteer their time to forums such as this, and they get some kind of credit on their, what is it called?
Continuing legal education, perhaps?
Yes. So we have those attorneys as well. So we don't go out without estate planning experts. We have our staff, Jim Gleffy and Kane Trin, who are jewels. I don't know what I would do without them, to come out to these forums with us to answer your questions. And it's important that when you go, that you ask the questions. But who says you know everything? You don't know what you don't know until you come here, right? So how many people have learned something since they've been here? And you can come to these forums as many times as you want until you get the right information or until it sticks with you, but you got to make a plan, okay? That's the purpose of us educating you in the community. You have to have a plan. COVID threw us for a loop. People left here and had no plan for transferring their properties or transferring their wealth. And we do this because we're passionate about it. We want you to keep your hard-earned wealth. So I want to thank our attorneys for coming out with us.
We do have one more question.
Really quick, what availability do you have for CDL for your offices?
So for our offices, we are a partner of the clerk's office. So I don't want to take too much time explaining this, but I do want to let you know, we also do outreaches. So we will go to communities. We partner a lot with libraries. We love librarians. You're the boots on the ground for us, really. And we will come out. We will talk about powers of attorney. We will talk about last will and testaments. If for homeowners, we'll talk about toadies. And then if there is enough interest, which typically is about 10 people who qualify for our services, we'll bring a team of volunteer attorneys out to you to draft those documents on site. And of course, we also have 11 community clinics, 2 of which are embedded and are there all the time. But we typically meet the embedded ones twice a week, and then the rest of them once or twice a month. And those are primarily on the south and southwest sides, but we're always looking at expanding.
So I want to thank our staff for coming out. Brian Cross came down. He was working the table upstairs, but he is our director for Veteran Services. So I'll let him explain to you what we do there. No veterans in the audience? No? But I'll let him explain to you what the Veteran Services Office does.
Good afternoon, all. My name is Brian Cross. I'm the Director of Veteran Services for the Cook County Clerk's Office. In essence, the Department of Veteran Services, if you want to tell your vet friends and neighbors, we have a couple different roles. Our most important role is the recordation and the retention of the DD-214s, which are the military discharge papers. We've been recording them since 1945. We have about 250,000 in our files. But if you have any friends who are vets, have them come downtown and record them. It's extremely important. Fire, flood, et cetera, et cetera. The second role we have, which is a little more fun for the vets, is the military veteran discount card. We have about 190 different merchants, including the Chicago White Sox. We just added the Chicago History Museum, and for those vets with kids or grandkids, the Chicago Children's Museum. And they can come in or they can go online at cookcountyclerk.com under veterans, and they can sign up for the card, and either way they'll get it real quick. If they come downtown, we'll be able to hand it to them that day. If they go online, I always try to clear my deck every Friday, so they'll get it after the weekend. So thank you very much. We're very excited to be able to help our veterans.
Great, thanks, Brian.
Of course.
One other thing, you got a property fraud alert registration form. Please fill that out. It'll help you protect your property. It's not going to prevent it, but it will help you protect your property against fraudsters. Yes.
Is it better if I don't have my PIN at the moment? Should I just?
You don't need your PIN to fill out the form. Okay. We can look your property PIN number up. And the other thing is, a lot of people don't know, they cannot go to our satellite offices to record their transfer on death instruments. They have to be recorded in our office at 118 North Clark Street in room 120. Okay? If you're interested in having one of these events, you can contact me, Robin Staggers, and the number is 312-603-3974. Again, the number is 312-603-3974.
Last thing about the fraud alert, you can sign up as many times as you want. It doesn't affect the system. So if you signed up a few years ago and forgot, you can sign up again. It's not a big deal. You can do that online as well. So FYI, okay?
So I want to thank Esmeralda and her staff here at the Chicago Public Library for having us out. We were supposed to come out last year, but unfortunately we lost our recorder of deeds, Karen A. Yarborough, and we had to cancel the event. So we promised that if they had it again this year, we would come out, and here we are. So if you have any questions, please see any of the staff that are here. If you have legal questions for our legal partners, they're here for a minute, or for our staff, they're here for a minute. And thank you so much, Esmeralda.